All right, this session will last as long as we still have interesting questions. And actually, if we stop after your question, it doesn't necessarily mean yours wasn't interesting. But we'll begin. What we're going to do is we've assembled a panel: Suzanne, Daniel, Heather, and Peter, which I will moderate as necessary. To reflect a bit from different parts of the program that we've had on some of the major challenges, the issues that are arising from the fairly wide-ranging papers we've had across the 2 days, and use that as a bit of not so much a summing up as a reflection on where other big issues that we may not have highlighted directly might lie. So I'm going to start with a couple of just general questions, and panelists can feel free to intervene as they want to on a particular issue, and we will turn to questions from the remaining audience, but we'll need the microphone for that. But we'll start with a couple of questions, and then if there are others that want to intervene, I'm happy to stop at that point and come back in with any others that I have later. One of the things I want to start with that this is perhaps not the best thing to say, the question of the relevancy of lawyers in courtrooms in some of these issues. I know you'd be disbarred for that, I understand. The presentation we had at the opening from Doug Wallace, we asked to do an overview of the challenges in the marine sector from a scientist perspective. A very different set of issues, very different categorization of the issues than we would normally engage in as lawyers, which, as you've seen across the presentations, are very jurisdictional in their orientation, who has responsibility for what, who has authority. Whereas he was approaching it in terms of what are the problems that cross over this inherently international space. And he identified things like climate change and its effect on the ocean, acidification, rising sea levels, add to that on the climate change side, migrating species, not just in the normal migrations, but the species are now actually shifting outside the jurisdictional boundaries within which we have traditionally managed them because of climate change. So a whole range of things in which the solutions do not seem to be necessarily based in hard legal solutions at the national level, but are global in their orientation. In the areas that you've been working on, what do you see as an appropriate legal response to problems that at times seem so global and so massive that they're almost beyond the grasp of law? That's one aspect of it, is how do we translate that into our legal system? And second, is there a challenge here from what he described in building regulatory systems that are adaptive, in the sense that we are trying to regulate an ocean that's changing while we're regulating? And does that apply in your sectors? How do we deal with a fairly rapidly changing ocean environment in some cases when we find that the solutions, legal solutions we had are not appropriate? And I'll throw that out open to the panel.
Go ahead.
All right, so I guess I'll get us started. So you may have heard, you started with the relevancy of laws and courtrooms, so I'll take it from there. You may have heard of the doctrine or the law of the hammer. So if you're a hammer, everything looks like a nail, they say. And I find that that is pretty prevalent in a lot of our disciplines. The more you become an expert on something, the more I think you see the world through that lens, and that lens primarily. And one of the things I find so fascinating about environmental issues, and I've looked at them from a legal perspective in a past life, and now from an enforcement perspective, which isn't exactly the same thing as a legal perspective. Occasionally I get to see them from a scientific perspective, like we did yesterday morning. And there are many other ways to look at it. We had presentations on the indigenous perspective and some of the rights issues that indigenous populations have. And there are so many different ways to look at environmental issues. And I think one of the challenges we have is that if we don't take all of those things into account, we don't actually have a proper solution. Laws and regulations are not the only tools, and not always even the best tools to deal with an environmental problem. The solution to every problem is not enforcement. I wish it were, because that's where I work, and I like to be able to help out in that area. But I think it's great that you included somebody from outside of this discipline in this discussion. It's a really important acknowledgement for us that we need to understand those various different perspectives. Otherwise, we simply can't tailor a solution to a problem that actually works. One of the things I always try to do in my work is to take a moment to study the problem we're trying to solve and really look at that problem and give that problem its own unique attention. That's the only way you're going to find out how to solve that problem. And if we're only looking at it through our narrow sphere, we're going to come at it at our angle and maybe not even necessarily solve the problem. We might actually make it worse by pushing in the wrong way. So I don't think that's a really simple or cogent or easy answer to your question, simply to say that I think all of those perspectives have to be taken into account if we're going to find something that actually addresses some of the serious challenges that we raised in the last couple of days.
Suzanne?
I was struck, you were talking about these global challenges, and I remember the map and these beautiful zones, a great slide, and the whole law of the sea reflecting a traditional is long-term elaboration and development has cut the oceans and classified them into these discrete zones when nothing really behaves in that way. There's a fluidity, and yet these zones have been the focus of structuring prerogatives and responsibilities. You also need, hopefully, to designate an actor, and often it's the coastal state who will shoulder the responsibilities of protecting that environment. So, and for me, the problem for me was the idea that individual nations or countries or coastal states don't have all the tools, don't have the capacity to deal with these transboundary challenges, but at the global level, it's just so messy, slow, and difficult, and all problems of lowest common denominators. So I do like the emphasis that you see in the Law of the Sea Convention, and I think that's being further developed, that maybe regionally, maybe some of these great challenges, maybe the middle point is to try and encourage regional cooperation. And because I work on the Arctic, I think the Arctic is maybe a promising area for fostering effective regional cooperation. And I think you were saying, flexibility in regulatory systems, and the Law of the Sea, I think trying to amend the Law of the Sea would be like trying to amend the Canadian Constitution. So we do find ourselves, so I was saying during the breaks, environmental law is just, Law of the Sea hardcore is more my thing, but I think I like the precautionary approach, and I think it's gaining ground. I think it's no longer a bad word to maybe just take time to let the science catch up or even figure out what is happening. So I think maybe big concepts like the precautionary approach may help us deal with pretty rigid rules.
Mm-hmm. I tend to be a little bit pessimistic about the ability of international, certainly international and cooperation to catch up with global problems. If you look at the sort of traditional shipping industry conventions, they spring from disaster. Yeah. So when you have those sort of absolutely global treaties, they're slow going. They're based on compromise and years of negotiation, and the intersection of many thousands of national interests and domestic politics in all those cases. But I think I really like, Suzanne, your idea of the regional approaches, because it's much easier to tackle something on a regional basis. For instance, the OSPAR Convention that deals with the North Atlantic, I think that is a more workable solution that addresses a particular region, the interests of a number of states, but isn't so unwieldy that it tries to be everything for every coastal state in the world. As far as on a domestic level, it's difficult. I mean, I deal frequently with the Offshore Petroleum Board here, where you have a system set up as a political compromise in the 80s into the 90s, which is enacted by 2 levels of government, is very, very difficult to get the consensus necessary to make amendments and to keep up with the times. All 3, the National Energy Board and Offshore Petroleum Boards, are currently working on a regulatory renewal process, but that takes a ton of work. There are a lot of players at the table and a lot of interests, given the federal, provincial, and 2 different provinces have these interests. One of the ways that the offshore regulators have dealt with that is they adapt through the application of conditions to, the making of guidelines, the application of conditions to approval processes and authorizations to fill in some of those gaps. That doesn't always provide for the kind of certainty that certainly industry would want, because it leaves it open to challenge, certainly. But that's one way that there can be flexibility at the domestic level.
I would agree wholeheartedly that the movement on the regulatory front may be slow and, as Daniel said, often reactionary. Where I am optimistic is in such things as the development of the duty to consult First Nations, Inuit people. Aboriginal consultation has come from 20 or 30 years ago being nowhere on the radar screen for developers and for companies that are actually going into these sensitive areas and affecting ecosystems and affecting the environment, to a place on their list of priorities that's in the top 3, if not the top 5. The use of traditional knowledge and relying upon traditional knowledge, I think, will allow industry and anyone who is looking to develop a project that may have an impact on the ecosystems or on the environment to think ahead a little bit on how they're going to plan their operations, and this way possibly avoid having to deal with some of the more difficult aspects of the regulations. There was a point made yesterday, or at least a series of questions as to whether or not how we use enforcement, and whether enforcement is a good tool to bring people in line. And I take Heather's point that sometimes it's not really the best tool. Don't ever underestimate the power of shame, and it is certainly something that we see in the shipping industry, mostly in the tanker industry, which probably does have, in terms of a segment of the industry, the highest risk quotient in terms of environmental issues. And oil and gas companies have developed what is called a vetting system. In other words, before they charter a vessel, this vessel has a blue card, has a passport. And the history of the vessel, all of the issues, port state controlled detentions, possible violations of any types of regulations, all go on this passport. And there is an obligation on the part of the ship owners to report any incident that has to go onto this passport to the oil and gas companies. This card is what gets your ship chartered by the oil majors. And if you don't have a completely green card or a practically perfect card, your ship is not being chartered. And the point, as I made yesterday, the point that your vessels are they're floating revenue-generating assets. And if you're not able to fix your vessel with some of the major oil and gas companies because you have a history of issues with your vessel and the operation of your vessel, you're in trouble. So there is a tremendous shift, especially in the tanker industry, the marine industry generally, but especially in the tanker industry, to develop best practices. And some of those best practices would absolutely include looking at becoming more involved in green initiatives and how to operate your vessel efficiently. So it's transparency and shining the light on bad practices has really proven to be a tremendous asset.
As anybody's jumping up, very helpful responses. I come back to something that came up in this discussion, and that's the structure and the impact of the Law of the Sea Convention, which laid out the jurisdictional entitlements, brought them up to date. But as a unique, or at least at that time as a new thing in international law, later mimicked to some extent in the Conference on Environment and Development and the other big environmental treaties that followed. The Law of the Sea Convention was really based on a broad compromise between, or reflection of, rights and entitlements of states, confirming coastal state jurisdiction and expanding it fairly markedly in some respects. And on the other hand, imposing obligations and responsibilities to manage the oceans in a cooperative way internationally and domestically. And I think it was a pretty fair assessment over a number of years that many states grabbed the jurisdictional opportunities wholeheartedly and promptly forgot about all the obligations that they had to manage. Canada, for example, established an exclusive fishery zone, later an EEZ, to 200 miles to preserve and conserve our fishery, and promptly proceeded pretty much single-handedly to destroy one of the largest fisheries in the world by over-exploiting it. So jurisdiction doesn't equal conservation, jurisdiction doesn't equal solution. How do you feel in the areas that you're looking at? Canada's progressed over the 20-plus years since the confirmation of a significant expansion of jurisdiction. Are we meeting now our international obligations better than we were? Are we translating this into enforceable obligations nationally? Do you have examples you can think of major successes or major failures?
If I could jump in, I work very much on the Arctic, and so my examples from the Arctic. So I didn't mean to, but I was invited at different times, different places to explain Canada's position in the North and the Northwest Passage, and it was problematic for me. I'll tell you that, to be honest, one of the senior colleagues in the United States, to give you the idea, the kind of the hostility, was saying Canada trumpets itself as a multilateral actor. At the first test of your national interest, you've gone all nationalistic on us. So, and that was John Norton Moore, so, and he was pretty red in the face when he was telling me that. So, and for me, I think that was a key. If you go back to the Island of Palma case and Max Hubert, and he was very careful to say that sovereignty confers rights and prerogatives, but also brings responsibilities. And for myself, talking about the Canadian position, it wasn't uncomfortable. For a while, it was a bit uncomfortable, as if we were, they're ours, there are historic internal waters, we control, and you know, there was some political messaging at the highest level that was very much reinforcing that kind of message. And for me, if I tried to stick to my, you know, what I've been taught very well over the years, what about the responsibility? So I think, though, that those presentations are becoming a little bit easier. I think there are positive developments. I like Transport Canada's new maritime initiatives corridors, that maritime corridors initiative that Peter mentioned, because there it's for me it's putting your mouth where putting your money where your mouth is, and it's saying that you're not just saying you're claiming the waters and that you'll act as a responsible steward, you're actually doing it. And so I think it's very much a part that's been neglected. And I think in the case of Canada, where there is some debate over some of its legal positions, it's very much in its own interest to be shown, to be seen, to be not just picking and choosing and benefiting from the conventional rights, but also stepping up and acting responsibly as a responsible sovereign. So.
I agree that we talk a good talk, and we've always talked a good talk in the Arctic. When it comes time to putting your money where your mouth is, I think we've not really stepped up to the plate, if you excuse my mixing of metaphors. But I say that over the last probably 10, 15 years. I think over the last maybe year or so, I have seen some movement in terms of freeing up some money to deal with some of the issues and some of the urgent issues with infrastructure development, bettering our charts in the Arctic, bettering our aids to navigation, in order to not just simply enhance vessel operation, but make them safer, and ultimately show that we are better stewards of the environment than we may have shown to be in the past. So it's not, I guess my point is, it's not just about setting out these beautiful initiatives and these ideas and these photo opportunities that some of our friends in Ottawa may love to undertake. It's a question of actually funding. The Northern Transportation Corridor is, and I agree with Suzanne, a great first step, because it focuses where the money is going to be spent. And you can't just go into the Arctic and spend it all over the place. It really makes no sense. If you're going to build new port facilities, if you're going to build, invest money with respect to updating charts and aids to navigation, it's best to concentrate it where 80 or 90% of the vessel traffic truly is. So now that we've got this prism, or at least it's being developed, the next step is to start freeing up some money to really get going on the infrastructure development.
If I could just jump in very quickly on that. I was comforted because it was going full guns and then it slowed down, but colleagues from Transport Canada who came to speak to us, a group of us in Quebec City, were saying that it has slowed down for additional consultation with local communities. And there always was traditional knowledge and Inuit input, but there's a second round to make sure that the designations of the principal corridors doesn't negatively impact on those communities and their cultural ties with the marine spaces involved. So I thought that was also very positive.
So if I could pick up on that, I'm going to take this from maybe some specific questions into something that I hope is not too much of a tangent. So you're asking, I think, of some examples where we've seen some positive movement and things that have come from big international conventions and treaties and have actually resulted in change. And I feel like I'm at the real nuts and bolts, on the ground, get your feet dirty end of all of this, being in environmental law enforcement. And you know, there are some international agreements that are things that I work with every day because they've become Canadian laws and regulations. So if you look at the Basel Convention, the Montreal Protocol, the London Protocol, these are all things that they've actually turned into laws and regulations that the people that I work with enforce every day across the country. One of the things I've learned in government, and I actually started in government thinking, oh, I'll just take this job for a little while until I can write PhD applications and then I'll go off and teach, which is what I really wanted to do. I stuck around because I learned something new at work every day, and they pay me to do it, which is a pretty good deal. The number one thing I've learned working in government for the last short period of 6 years is how to implement, and the importance of how to actually take an idea from something that seemed, you know, a lofty aspirational goal and turning it into actual real change in the world. One of the ways that's done, if you trace something from an international agreement, a moment in time where you actually manage to get people from a whole bunch of different countries to come together and agree to something collectively that may actually have some meat to it and hasn't been so watered down by consensus, that we have something that is meaningful. So you've got your lofty international goal and you've got your international instrument that obviously has to be enacted into domestic law for it to have effect anywhere, because that's where it really breathes life into the day-to-day. Then when you've decided to enact it into domestic law, you've got to come up with some way to make people actually change their behavior, because that's what all of this is about people changing their behavior. That could be done through financial incentives and investments in infrastructure. That could be done via a series of analyzing what the barriers are to people's changes in action. There could be a law or regulation that ends up getting enforced. There could be really terrific and sophisticated compliance promotion that pops the information in front of your face through a Google search just when you need it, and really that was an algorithm that someone set up for that purpose. And this is just all off the top of my head right now. There are so many different ways that you can move human behavior. Once you've figured that all out, which is quite difficult to do and quite sophisticated analysis, then you actually have to have people who do it. So I've learned a lot in the last 6 years about the importance of, if you're looking at government action, of bureaucracies and making sure that they have the right funding to actually achieve the goal that you want and the right resources, and that there aren't too many things getting in their way. And the importance of the power of personalities, of having the right leaders in charge of some of these things. And I think I was at a talk a few weeks ago given by Professor Stavens from Harvard University, and he was talking about climate change, and he was saying academics sometimes forget the power of personalities behind things. And he told a story about how at a climate change convention, how someone had stood up and said, consensus doesn't mean we all have to say yes. That there just has to be a groundswell in a certain direction. So, you know, all due respect to you naysayers, we're coming this way and you don't have to go with us, we'll go by ourselves. And he was talking about how that had been a watershed moment. And it made me think about some of the things I've seen happen in government that from the outside look like some kind of conspiracy or some strategy, and really it was just some amazing person in the right place at the right time who brought something forward, or the opposite. And so some of those things really do matter. And that may actually sound like we should all be pessimistic, because I just outlined about 1,000 moving pieces. But despite all of that, we seem to get it done sometimes. And I think it's pretty remarkable when we do. Some of it does come from crisis, as you mentioned, particularly in environmental law. But there are truly inspiring moments we see sometimes when people actually get together to do the right thing. So I'm still quite hopeful about all of that, despite the complexity I just outlined for you.
Agreed. Nothing to add. Yeah.
I'd just like to throw a couple of things in, picking up on both of your questions. One is Canada, the Boy Scout of the international community. You know, if Sweden is the librarian telling everyone to be quiet, Canada has done this, and I think I think other nations sometimes have reason to point to how we actually behave when our interests are at stake. And one thing from the Arctic that I think is worth citing is when Canada drew these remarkably generous baselines, one of the arguments was based on really an extension of Anglo-Norwegian fisheries, that, you know, the people are the sea and the sea are the people and so forth. And when it came time for devolution of powers to Nunavut, it was no. That's something that the federal government has to look at, even though apparently these noble guardians of the sea were one of the reasons we were entitled to have internal water. So I agree. We can sometimes, I imagine, be a bit annoying to other states who think we're a little more realpolitik than we pretend. And I'd also like to just go back to the comments about essentially the limits of law. And I think one really good example of that is how Canada manages its international freshwater resources. The Boundary Waters Treaty, which essentially does that, by anybody's standard, is one of the most archaic and ridiculous treaties in the world in terms of the principles. It enshrines the rights of upper riparian states, the absolute right of upper riparian states. It doesn't seem to involve groundwater, has a mention of pollution, and that's because it was concluded well over 100 years ago. But that said, it works pretty well. And the reason it works pretty well is because it has an institutional capacity, and the institutions have, by and large, just ignored the principles in the treaty and got on with managing. And I know that they sometimes have a real distrust of lawyers. I can remember in a Canadian context where they were negotiating an interjurisdictional agreement. I won't say which one, but it was in the West, and it was being negotiated by basically fairly senior managers from several provinces, and they had one rule, and that is no one could bring their lawyers with them. Which ended up being a little odd, because one of the things they did is they put in an appeal provision to the Exchequer Court, which of course doesn't exist anymore, but they found it in an agreement that they liked. But the truth is, if you look at in a Canadian interprovincial context, we never litigate, right? We will do anything to avoid litigation, and in fact, most public servants will try and avoid even going to ministers to sort things out. So you actually look in North America, the regime we've done in the Great Lakes in terms of water quality and so forth, there have been failures, but there have been some real successes. And even building on that, probably the most successful recent developments there have been without the involvement of the United States or Canadian governments. And it's been the Great Lakes Charter involving the provinces and the states getting together and just working practically. And a lot of that just depends on
Gulf of Maine
cultural
too, yeah.
ties, similar legal systems and so forth. And to see the contrast, all you have to do is go down to the Rio Grande and see how the Mexico-U.S. relationship works. And even without that big wall that's we're apparently going to be built, it just doesn't work as well as the U.S.-Canadian one, even though, as I said, the underlying treaty and the principles in that are not principles we'd ever put in any international arrangement today.
I should say they occasionally litigate against, having been unfortunately involved in one of them. Anybody from the floor would like to chip in at this point? If not, we'll keep going. Yes.
I just can't hear myself, which is probably a good thing. I'm sort of throwing out a proposition here, which I really don't know a lot about. But just listening to the various themes that have come up, I'm interested in what people have to say about marine protected areas. The federal government has established some fairly ambitious targets for the creation of marine protected areas, and is also throwing some money at doing so. And it seems to me that a marine protected area involves all of the kinds of interests that we've been talking about. If Canada is a good Boy Scout in terms of its rhetoric, but needs to demonstrate how effectively it can work on the ground in protecting marine interests, it seems to me that the establishment of marine protected areas acts as a real lightning rod for the ability to do so. It just because of the fact that it is going to have to engage all of the interests, the oil and gas industry, the marine transportation sector, the fisheries sector, and obviously Aboriginal and community interests as well. So that the establishment of a marine protected area is going to have to presumably establish not only coordination between the various divisions of the federal government that are involved, Transport Canada on the shipping, DFO on fisheries, parks on and environment on protected areas, but also engagement with the rest of society and coming up with workable arrangements that are going to have the kind of social license that we've talked about as being necessary. It seems to me that there is something very concrete, very real, that engages all of the various things that we've been talking about that, maybe can become a focus for very concrete action over the next short term, say 5 to 10 years. In that context, I'm very interested in what's been said about the Indigenous engagement and consultation with Indigenous governments and peoples. I think that that's an area where Canada talks a good talk, is a good Boy Scout in rhetoric terms. I'm not so sure that it's that good when it comes to actually doing things. And I think that one of the problems with the whole consultation rhetoric is that when it comes to real and meaningful accommodation, that is something that easily gets sloughed off. So, for example, the Muskrat Falls development, which threatens to generate methyl mercury contamination of the downstream environment. The Inuit have been very concerned about that. They expressed their concerns through the environmental assessment regime. They did so during the regulatory process. They've taken judicial review actions. and the problem persists. So I think that Canada talks a good talk about accommodation and talks a good talk about consultation, but I'm not sure that when it comes right down to it, it actually produces real results on that front either. I think that the issue of changing behavior is an issue of changing behavior towards our Aboriginal and Indigenous peoples more perhaps than in any other sphere. And that's the issue, that's how reconciliation is eventually going to take root. In that context, I find it very interesting that you talk about the reluctance of provinces to sue each other, to take their disputes anywhere other than to resolving them and making best efforts to resolve them without litigation. The Indigenous peoples call for government-to-government relations, and yet one of the greatest growth areas in litigation in the country is between the government and its Indigenous peoples. And I think, if anything, that illustrates the degree to which a government-to-government relationship may be something that a government will espouse rhetorically, but that when it comes to making it actually work on the ground, you see everybody in court.
Lead off?
Could I? Yes, please. Because Linda and Magdalena would probably want to jump in. I took too much of their lunchtime actually, asking and talking about marine protected areas, because I was asked at one point to talk about marine protected areas, and after doing the research, just starting to find out about it, I was very skeptical. So I wanted their opinion about this mechanism. So it seems like a wonderful thing, and I think it's here to stay, marine protected areas. But one of the things I struggle with, and its strength is its weakness. It's touted as a flexible tool, flexible marine management tool, but that flexibility comes from hard decisions about how to reconcile competing interests in a maritime space. And we're talking about Magdalena, who's involved in one of the biggest and, well, very important MPA in the north of Canada. That is quite time consuming. It's quite the delicate balancing exercise. And so my first level, and I'll let my colleagues jump in with their thoughts. The way I'm coming at it is now the Arctic Council is pushing for, and the Arctic coastal states have all jumped on board, an integrated network of marine protected areas in the service of ecosystem-based management or holistic management and sensitive to local. And I just don't know how that can work. We were discussing how long it takes to establish an MPA domestically, reconciling all these interests. And I want to believe in it, and I know it holds promise, but I find it's a very time consuming, and I was shocked, maybe Linda would jump in at this point. I was asking Linda, because people think, I was thinking there was this a savar, a flavor earlier that, speaking about Nova Scotian MPAs, that it's a nature reserve, so shut out, closed off, just for pristine nature concerns. And first of all, that provokes a negative reaction, and then I wanted to know, is that really, because there's a whole slew of management regimes that you can put in an MPA. So Linda, maybe you want to say
We were talking a bit about the MPA, and that was the history, because I was working from 1996 to 2006, and the establishment of what became 3 marine protected areas in the Beaufort Sea. But they were, for Beluga, they represented zones that the Inuvialuit wanted to protect under their land claim, and they put it under there as a Beluga management plan. And so this was a gradual formalization. So the MPA, it was a lot of balancing of interests, particularly more government departments. And industry, and even some of the Inuvialuit, because they have divided interests too, because they have a regional corporation as well as a more conservation arm. But that was an interesting one, because the protection was already there. This was to formalize it in the future. But when I was at the Arctic Council with Conservation Arctic Flora and Fauna 2002 to 2004, we were talking about MPAs. That was one of our mandates, because that was the focus of the marine conservation in our group. And at that time, there was a sense for ecosystem-based management, which Canada was adopting, but then the US wanted to have large ocean management areas. And this MPA historically that was going on in the Beaufort Sea, the federal government was for MPAs, and then it was for large ocean management areas. So policies change and focuses change. So I guess I'm throwing that thought out there too. Is it the name or the objective? Like Europe's going to do ecosystem-based management under the Water Framework Directive and the Marine Directive. We're going to do it under the Oceans Act. The US is going to do it another way, and it will all somehow work out. But that's not really good to tell to lawyers, is it? Or to look at conventions, but that's in practice what's probably going to happen. I wanted to one other thing, and this was just a comment about disappointments. I think in Canada we also need to celebrate someplace we have successes. And I think the northern part of the country under the land claims is a success, not necessarily because the federal territorial governments take the lead, but because we've created these structures that are now working, which really mostly embed local communities, look after Indigenous interests, slowly move forward with things that need to be done up there, sometimes of their own volition, sometimes with government support. So I just throw this thought out there, in the marine and coastal zone, I actually think we've got a lot of successes for half the country.
Yeah, fascinating topic and interesting question and starting us off on this discussion. So first of all, about the targets. I think that the government's taking them very seriously, and it's an interesting question of our international law obligations, soft law, and how we're turning them into domestic law, going back to an earlier point, because Canada did sign the Biodiversity Convention and is a party to that and does participate in the annual Conference of the Parties. And so the Aichi targets from 2010 set these targets that the government has now committed to in the mandate letters. So at least 10% of ocean and coastal areas by 2020, and at least 17% of terrestrial areas. So I think they're taking them very seriously. Part of that Aichi Target 11 also, which is about the MPAs and the protected area targets, talks about protecting through effective legal means and other effective area-based conservation measures. That's a phrase. And it means, I was told by people who negotiated it, that was to account for Indigenous declared protected areas. So there you see a good sort of reflection of the fact that Indigenous law may play into international and domestic law in that sense as well. So right now there's an IUCN task force that's trying to come up with guidance about what these OEA BCMs really means, the other effective area-based conservation measures. We have some good guidance here in Canada on that. And I just wanted to talk about the Indigenous law topic that I was talking about a bit yesterday. In BC at least, and I'm sure probably in the north, some of our marine protected areas have grown out of sites that were declared under Indigenous law first. So the Guayhanas started as a Haida heritage site declared under Haida law and grew and became Guayhanas and became Guayhanas Marine Conservation Area. And we see that in other areas in Clayoquot Sound, for example, Mirus Tribal Park. So there are other, and there's a whole literature on Indigenous community conservation areas, again, given some recognition under the Biodiversity Convention. This is a nice complex topic. Is the government moving fast enough? Certainly other governments haven't moved. And there's this real dichotomy about how we protect areas on land and at sea, because we have done quite well. There's a whole movement about nature needs half now, half the world, half the planetary space, but we've done pretty well about creating parks on land to some extent, but not so well, especially in Canada, where we're at like 1.4% of our marine and coastal areas are actually protected, a long way from the 5% we're supposed to reach by the end of 2017 and the 10% by the end of 2020. And why is that? I think part of it is this way we look at the ocean. And the ocean is this vast, limitless, freedom of the high seas, right of innocent passage, public rights to fish. It's sort of this big, huge, open domain, and we don't need to protect it. But we know that's not true. We know it's suffering, and we heard, I think, yesterday morning from our science presentation, the ocean's under immense stress, and we will suffer as humans if we don't do a better job of protecting it. It is not only feeding us, it's regulating our climate, and it's providing so many other important services. So the last thing I wanted to say was, again, in terms of doing a better job of working nation to nation with Indigenous nations on a government-to-government basis, we do have a success story. So we'll get back to the success stories that we want to celebrate. And the success story I already referred to it, this Marine Planning Partnership, but on the terrestrial side, the Great Bear Rainforest Agreement, it's in northern and central BC, and it was just finally got legally secured this year after 10 years of additional negotiation. But the First Nations in the area didn't like the idea of locking up a lot of this old growth forest as parks. And they didn't like this idea of parks because traditionally they've been excluded from parks. So I thought the brilliant legal move that some of my colleagues were involved in was to create a new form of protected area designation called a conservancy. So it's a new form, it's under our Park Act, but it allows traditional uses. And it's something worth looking into. So I think that is a real success story. And as far as I know, it's the only protected area legislation in Canada which specifically, well, that's not true. Anyways, it's an innovative form of protected area designation. So we do some good stuff, but we certainly have to accelerate it, and the ocean really needs help. And I'm happy that our governments set some hard targets and are moving towards them. And some of them do need to be strict nature reserves.
And I'd just add in on the MPA, which I tend to agree is we're seeing stuff now from scientists that don't think of it as the management tool by which you're going to manage the oceans, because you can't, that it's just more targeted and helpful in some circumstances, which means that I think the original international numbers by area were probably not as helpful, but I can see why they do that politically. But in the Canadian context, it's a good example where you have large maritime zones as opposed to coastal areas. The implementation of MPAs in any significant way beyond the territorial sea, and even to some extent in the territorial sea, runs up against a fundamental jurisdictional problem, is that you don't actually have jurisdiction in the exclusive economic zone to declare sort of full use MPAs that restrict anything that is internationally regulated. So in the Gully, subject to an MPA, both within Canada in terms of playing off the interests of the boards and oil exploration, but also internationally, where shipping is governed through the IMO and international agreements, we had no right to tell people without IMO approval of some kind that they could not use shipping. Somebody had declared at one point, one of the conservation groups actually proposed that we declare the entire Grand Banks an MPA and bar shipping from it. And it's just, well, that'd be nice, but nobody would permit it. So there is a jurisdictional issue. We have it inside Canada as well. As soon as you move out offshore a bit, you have limited tools you can apply, and you have to use a virtual management system where you draw the different organizations in that have jurisdiction and make sure they're on board. And the second thing, and I will toss this out, that has troubled me in some of this in conventions, is that we tend to adopt things like MPAs at a time, or ecosystem management, which is a popular one, despite the Law of the Sea Convention being designed around jurisdictional silos for different industries. You've got shipping, you've got oil and gas, you've got fishing, but then we're talking about an ecosystem management approach that somehow, not yet fully defined, is going to take all of those into account at the same time. Difficult to do, we haven't got there yet. And added to that is a problem that I really appreciate anybody who sees a better way to go about it, is how we integrate the scientific insights, scientists who work one way, with what lawyers try to do in resolving situations, because we tend to take their advice and put it in law. And we did that in the Law of the Sea Convention. And the problem was that the fisheries management tools we adopted were really current in 1978, 79. Likewise, what we thought the continental shelf looked like for the continental shelf provisions. So we enshrine in law a scientific answer, which as far as the scientists are concerned is just something that they're proposing now until the next person comes along, knocks it down, and says something better. An example I use, if we took the same approach to fashion, we'd all be wearing Nehru collars and a lot of paisley. It doesn't really work all that well. How do we make that transition, or is it something that we just have to live with? Any scientists here?
No, those are all good points. Of course, you know that they are negotiating in areas beyond national jurisdiction, sort of side agreement about creating MPAs on the high seas beyond limits of national jurisdiction. Right now, that's a current topic of international negotiation. And also, there are tools at the international level to deal with some of these jurisdictional issues. So the Great Barrier Reef, the world's most famous MPA, is also an IMO particularly sensitive sea area and a UNESCO World Heritage Site. So we do have some of these international tools that can be brought to bear on our domestic areas as well.
Yeah, I think that's what I was referring to when I mentioned the IMO provisions that do allow you, but unless you go and get that approval, nobody has to pay any attention to it.
But I think we're sophisticated enough to know how to do that.
I think,
I would just say though, but just having looked at the Australian Great Barrier Reef MPAs, it initially stretched to cover the Torres Strait, and looking at that, you know, because I've tried to do my homework. That time was Ash Roach saying, "There's enough international legal tools. What the heck do you need internal waters claim for?" And Ash Roach is somebody who deserves. So I started to do my homework. So PSSA, as you mentioned, but the thing is, IMO is very much strongly oriented towards safety and, of course, security, but of international shipping, navigation. And it was really interesting to see that they were all fine and good with approving a PSSA for the Great Barrier Reef and kind of putting measures. But when Australia produced a file, if you believe Sam Bateman, quite strongly about ecological considerations also affecting the Torres Strait. Oh, wait, ships use the Torres Strait, and suddenly you're going to ask for pilotage and stuff. No. So I agree that there are some tools out there, but the balancing exercise at the international law, especially if anything to do with the IMO, I'm not sure environment is on the same equal footing as shipping concerns or economic concerns at this point. But
I'm interested. The question was a very good question, because how do you take a reality which is dynamic and really codify it into a structure that is meant to be static? I mean, the whole point of codifying rules is to create certainty. And the difficulty is that you're quite right, that certainty is based on the snapshot of the reality of the time, but that reality tends to change. I'm wondering, I know that in certain, there is some legislation in Canada dealing with certain aspects of maritime law where there is a compulsory review process. And the whole purpose of the compulsory review process is, in fact, to take into consideration changing situations, changing mores, changing realities. And I'm wondering if that may not be the answer, just have a compulsory review process. And you don't have to review the whole structure of the convention. You know, the convention could remain relatively static and subject to amending formulas that are very complex. But from that, carve out certain aspects of it which tend to be a little more flexible in terms of amendments, and possibly some of the environmental issues is an area where you can set up panels and have on those panels scientists who actually know a little bit more about what's really going on than the lawyers do, and then just call in the lawyers when it's time to paper something. But I do want to, if I can, because there were a couple of comments made. I want to comment on something Magdalena said, and also. The gentleman over here, one of the comments I found very interesting. I agree with Magdalena in that we got to celebrate our successes, and I'm waiting to see how, you know, once the devolution talks with Nunavut start kicking into full force, and how they develop, and how generous, if you want to call it that, the federal government will be with during those talks. I certainly think that they've got to unshackle that poor territorial government called the Government of Nunavut, who seems to, every time you look at it, be charged with having to supply all the services up in Nunavut, but have absolutely no rights of revenue generation, and is tied to the federal government handouts every year in terms of what the budget's going to be. So I think there's a bit of an issue there that they still need some work on. I was interested with the question about how do you, and the Muskrat Falls situation, how you really deal with the concept of real and meaningful accommodation. I'm not sure we'll ever get to the point where we truly understand, or truly get to the point where we can say that we have now fulfilled our obligations to provide real and meaningful accommodation. We saw that situation come up, or the issue come up a few years back, and you may remember federal government and had allowed, given a permit for a very, very expensive research vessel to come into the Lancaster Sound and to conduct some seismic testing. And our friends at the NTI and the Inuit in the area took issue with it and went to court and sought an injunction about 3 days before the seismic testing was supposed to start. Putting aside all the money that was lost in terms of the cancellation of the charter and you know, all those issues, one of the arguments, and there were many, but one of the arguments in order to deny the application that the federal government put up and the proponent of the seismic testing was that the Nunavut Land Claim Agreement actually created a roadmap for consultation, and that it was a check off the box system. And once you've checked off all those boxes, you are done with your duty to consult. And the court, in actually granting the injunction, said, well, no, it's not. And the Supreme Court has been clear, it's not a static process, it's a dynamic process. And consultation must continue. And it's not just, you don't get to the point and say, all right, we have done with consultation, we can move on with our projects, thank you very much, close your books and walk away. I think we saw that, actually not that, we saw the opposite with the Mary River project up in Baffin Island, whereby from practically the get-go, Baffinland Ironworks and ArcelorMittal had boots on the ground in terms of consultation, and that consultation process continued, and it's continuing today. The project has been ongoing. There's going to be extraction. If it hasn't started already, it's going to start very soon. But the consultation process, in order to understand what the issues are of the community, is an ongoing process. It's a dynamic process. What happens in the case with Muskrat Falls, where we have a situation where it's a yes and a no? You've got the community is really saying no. It's not a matter of finding a proper way. This is not a good thing, and who becomes the arbiter of that situation when in fact you've got a drawing of the line in the sand and saying, you got on one side saying, look, we've done everything we can, we want to accommodate, but on the other hand, we just can't. We're being told we can't do enough. Is it the courts that say, all right, enough has been done, and we allow the process to move forward? I'm not sure, and I'm not sure how we can crystallize a rule and say, all right, there has been real and meaningful accommodation. We are assessing it as having been done. Period. Move on. Yeah. I don't know if we ever get to that.
Yeah, and I'll just jump in here on the duty to consult and accommodate point. It's important to remember that it's judge-made law, and it's been evolving and evolving over the last number of years. It's very difficult when you have situations like Peter just mentioned, where it's a yes or a no. It's the accommodation is essentially looking for a veto, and that may be the right answer in some cases, but there are going to be very sharply divided views about whether there is even a need to accommodate, given that the right is proven or claimed or whatever it may be, setting out, looking at the Supreme Court's tests for the spectrum of accommodation and consultation. But unless those negotiations are set up in some sort of framework, like a modern treaty land claim agreement kind of thing, that is acceptable to both the government or the Crown, whichever level, and the Aboriginal group, then the ultimate arbiter will always end up being, unfortunately, the courts, and you will end up with some very, I would say, inconsistent decisions, because the courts ultimately end up coming down to one person, and then three, and then perhaps 7 or 9. But the duty to consult is a very thorny issue, because you will always have the differing views of where that accommodation should lie. the Supreme Court has answered the case in the case of Aboriginal title, then there can be a veto subject to the federal government or the provincial government going in to prove that it has, infringed the right in a way that respects the Constitution. But as Peter mentioned, where it's an absolute yes or no situation, that it's a very difficult area.
Just a quick comment on the Clyde River, because I think it brings up some bigger issues too, because that was a seismic one where it was outside the full land claim process. It was more under the NEB, so even though there was a limited consultation, it wasn't through that same process. And so that probably why there wasn't buy-in, but I think there's a really bigger issue there, like, and this is the same thing if you were involved, Peter, with the Mary River, you know, there was a big concern about the ship-based traffic going to Baffin Island. It was going by the northern Quebec coast, where there was a lot of sensitivity for marine mammals, and then it was going all the way up to Baffin Island and the west side. And then there was a real concern about how species might be affected, particularly migratory species that are really food important for that whole area. And there was a lot of different jurisdictional, and they did a lot of compromises in terms of the frequency of the vessels and the fuel of the vessels. And still there'll probably be ongoing concerns depending on the impact and routings, which is the shipping corridor that was mentioned by Suzanne. But one of the other things to think about is right now in Nunavut, and this is particular to Kivalliq, there's 70% food insecurity. So 70% of households have problem getting enough food to eat on a daily basis, and that's largely because of the disappearance of country foods and the fact we don't have any subsidies for transportation of food goods to the north. So, and then you combine that with overcrowding and other health issues, some of the stuff like putting a seismic in that can take away an entire community's food base. And I know from working with DFO historically, there was the US military wanted long-range sonar, and then we're finding increased beaching. And then if you look at some of the seismic that was proposed, it was quite intrusive. And during a primary migration season. So there's a lot of really significant issues where you might have to say no unless you want to change your entire food source and economy up there.
Seismic's an interesting one. I think a very different context there because you have identified harms right away. More difficult in the open ocean where some harms are identified, but perhaps reflects a flaw in our legal approach to approving major oil and gas projects offshore is that seismic is often the thing that gets attacked fairly early on. And I think for some of it for legitimate reasons in their own right, but quite honestly, and from people who have been engaged in it have said, that's the line in the sand. People don't trust the government to not develop the oil and gas once they find it. So you launch your attack at the level of the first thing that moves towards finding the oil and gas, which the industry finds frustrating, I think. But on the other hand, the parties who are concerned about the impact of the oil and gas development are equally frustrated because they feel they have to do it that way because they're not going to have a chance later on in the process. It's not going to be it's going to be a foregone conclusion in terms of approval of the major projects. Pardon?
That's an interesting, if you start looking at that seismic was for an area that's probably never going to get developed.
Yeah.
That one.
Well, as I say, that one has distinct
So they might have wanted to do the
Yeah.
seismic and they got a proposal together, but if they can't even develop the known reserves in the Beaufort Sea, they're not going to develop it up there in the Eastern Arctic. So you might have a legal right to do that, but you're putting a whole livelihood at risk
Yeah.
for a resource would probably never be exploited.
Yeah, and as I said, that's very different from the situation we ran into in the Gulf of St. Lawrence, which is what I was referring to.
Yeah, and certainly, my point in discussing the duty to accommodate was not to say that an absolute no isn't the right answer. An absolute no may be the right answer in many cases, but it's the identifying and who is the ultimate arbiter of whether it's a yay or a nay or somewhere in between is the question will still fall to the courts until the negotiation process is more, I think, better framework for it on both sides.
So Philip, you've asked a question a couple of different ways that we keep avoiding answering, so I'm going to take a stab at it. And even though it's not necessarily my true area of expertise, much like Chris earlier today, that's not going to stop me from talking about it. Here's what you were getting at earlier that I heard anyway. You first asked about building regulatory systems that are adaptable. And then just now you were asking about how do we deal with changing science, that something comes into a law or regulation and then decades later we're still stuck with that old science. So that's something that I've observed. I don't make regulations in my job. I have people who I work with who enforce them. But I do observe the regulatory making practice quite often. Most regulatory making bodies tend to have some sort of process that they follow to develop a regulation. I'm not always a big fan of process. I usually just like to jump to the action. But I've developed a great respect for process in things like this because the topic of silos came up yesterday, I think, and then again today. So most regulatory agencies will have a process that forces the regulation to stop at the station of each of the key silos on its way to becoming real. And they do that because each of these silos has other things that they're working on a daily basis that aren't that reg, but they're involved in that regulation in some way. And if that process is followed, and they often are updated from time to time and made better, sometimes things really do come out that are good and work in the real world. What happens more often than not is that there's a lot of pressure to get something done fast because it takes government a really long time to do anything, which used to be a complaint of mine until I joined government and realized why it sometimes takes so long. If you try to speed that up, what ends up happening is you start skipping stops. You miss a silo entirely and you don't get that perspective into your regulation. So you wind up with things like a regulation that points to a laboratory method that doesn't exist, hasn't been developed yet. Or to something that there isn't a lab in Canada that can do it. So it becomes impossible to comply with that regulation or to verify compliance for my staff because that doesn't exist. There's tons of examples like that of things that you'll see. And also regulatory agencies do try to make regulations that are flexible and adaptable and can keep up with changing times, but sometimes that can cause other problems. So you'll see language like the regulated parties have to use the best available technology. That sounds fantastic. So today the best available technology is this, tomorrow it will be this, and that's what we're going to do. That's great. The problem is that becomes very difficult to enforce. What is the best available technology? Who decides that? And is it the best available technology or the best available technology that it's reasonable for that entity to have purchased and used, which is what they're certainly going to argue. So that adds another element of complexity. Sometimes regulations will point to a standard that is dynamic and will change over time. Again, an effort to keep up with changing times. And I think that can be done very well sometimes if it's a standard methodology like an ISO standard or something like that, where you've got a body that is governed. That works out very well. But if it's something that points to, so if it points to guidelines, the problem you have then is that the guidelines themselves are not enforceable. So somebody is subject to following certain guidelines, and the guidelines will say something like, one might do the following, or the best way of doing X could be blah, 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 blah. So if you haven't done that thing, are you still complying with that guideline? Or parties should contemplate the following things in making their decisions. You can imagine how that, and of course I'm always thinking of it from the enforcement angle because that's my world and that's the focus I need to take on it. So then I have to have an enforcement officer try to explain what you may have contemplated on a given day making your decisions and then prove that beyond a reasonable doubt. So that could be quite challenging. I don't think, again, I don't despair about these sorts of things. I think what I usually insist on whenever I get involved in a new regulation is that, you set your red lines for the things that are the most important. So if we have science that's telling us that a certain thing is quite dangerous, you set that line in the sand. And that's the thing that you want to make enforceable, and you throw all your ducks in that particular row. There may be other things that are less important, that are a bit more aspirational, and those things can be put in something that is not meant to be enforceable so that it can be flexible and dynamic and keep up with the changing time. Maybe eventually that becomes an enforceable tool when we have more science that can help out. But it's quite difficult to make these things adaptable. I think law by its very nature is slow because we don't want brand new rules happening every day in such a cluster of confusion. The common law is helpful in that regard, though, in the sense that judge-made law can come faster sometimes than laws and regulations, and the interpretation of laws and regulations through real life in the courts. That's where actually lawyers can add that element of dynamism to this because they're pushing the envelope and changing the way that things are interpreted.
I mean, those are actually quite interesting examples, and another, again, totally different context, but bringing international law in a changing form, but still predictable enough. Things like the ozone agreement, which actually has in Canadian law references to decisions of an international body and adopting them by reference so that you're continually moving things along, and they're similar in the coastal fisheries protection provisions for adopting the decisions of regional fisheries organizations, bringing them in. I mean, I can't imagine the American government agreeing to one of those, but it actually is, I think, in some of those cases turned out to be a fairly practical way of adapting to an internationally evolving, not necessarily a scientific consensus, but a management consensus fairly quickly without going through a full regulatory process. Doesn't mean you have to go look up the decision of the international body to find out what the act actually means, but other than that, it's fairly helpful. Are we ready to finish, or anybody else? Going once, going twice? I would like to thank our panel very much for agreeing to take on something utterly unpredictable in their own right and stepping outside their normal jurisdiction. Thank you very much. And I think now we're going to turn over to Alan.
So in terms of closing remarks, I hope that you've all found the last couple of days' sessions to be informative. This has truly been a collaborative effort on behalf of the Marine Environmental Law Institute, Dalhousie University Schulich School of Law, the University of Calgary Faculty of Law, and the Canadian Institute of Resources Law. We would like to thank all of the presenters and members of the audience and the panel for your contributions to make this symposium a success. Secondly, we would like to thank Environment and Climate Change Canada for an informative presentation, a valuable panel contribution at the symposiums, and their contributions, financial contributions during the last 6 years for these national symposiums. Thirdly, I would like to thank Philip Saunders, Owen Saunders, Nancy Money, Laurie McDougall, and our able audio, visual, and webcast folks, who've, particularly this year, resolve some challenges for their individual contributions to this year's symposium. I would like to remind the members of the audience that, as with prior symposiums, papers presented at all of these symposiums are available in both official languages on the Canadian Institute of Resources Law website at www.surl.ca, and that the webcast recordings, questions and answers will also be available on the same website to get them back under the symposium tab on the website. Merci beaucoup, and I hope you enjoy the balance of the day. Thank you.